You that you speak right into your microphone when you answer, if you could, please.
Okay. And don't say asshole. Because we get picked up.
Mr. Lally, go right ahead.
Thank you, Your Honor. Now, Ms. Vallier, we talked about sort of the physical match or mechanical fit analysis that you did with regard to each of the items individually, correct?
Yes.
And can you explain for the jury the process that you undertook in your physical match analysis between different item numbers?
So between different items, amongst the questioned ones, I only compared the pieces that were large enough to have a label on them. Some pieces were quite small. I utilized several benches and divided them up into sections for each item, and individually pulled out all of those pieces. And then I had another bench where I did the actual comparison. I started with all the pieces of the same color and looked to see if any of those had potential edges that could match.
Now, with respect to items 715 and 716, did you do a physical match analysis between those two separate items?
May I look at my notes?
Yes.
Okay. Yes.
And what, if any, conclusions did you come to in relation to your physical match analysis between item 715 and item 716?
Two pieces from item 7-15, F and H, fit mechanically with two pieces from item 7-16, F and G.
And what, if any, conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716?
Those four pieces were at one time together as part of a larger unit.
Now, Ms. Vallier, what physical match analysis did you do with reference to items 7-6 and 7-11?
So one piece from item 7-6, piece B, fit mechanically with one piece from item 7-11, piece D.
Oh.
So those two pieces were at one time together as a larger unit.
And Ms. Vallier, with reference to items 7-8, 7-9, and 7-16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those three items?
So two pieces from item 7-8, pieces C and D, one piece from item 7-9, piece A, and one piece from 7-16, piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
Lastly, for this section, at some point, did you do a physical match analysis for the glass pieces in items 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or parent glass pieces from 7-12 and the glass piece from item 7-14.
Now, Ms. Vallier, are you aware that there was an additional analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
Okay. And do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
Okay. And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8, many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially removed the items from those individual bags, placed them on the table, and examined them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one date that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1. Again, for the jury, what is the physical description associated with item 3-1?
Item, passenger side taillight, Massachusetts 3GC684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any, conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
There was a physical match with, do you want me to list?
If you
all
could,
of them?
please.
Okay. So 2 pieces from item 7-5, 4 pieces from item 7-8, 1 piece from item 7-10, 4 pieces from item 7-11, 2 pieces from item 7-12, 2 pieces from item 7-13, 4 pieces from item 7-15, and 4 pieces from item 7-16 were found to fit mechanically with item 3-1.
And what, if any, conclusions were you then able to draw from your physical match analysis between item 3-1 and each of those respective items beginning with the number 7?
Those pieces were once together as part of a larger unit.
May I approach, Your Honor?
Yes.
There, I'm showing you 3 additional photographs. Do you recognize what's depicted in those?
I do.
And what do you recognize those?
This is a comparison between item 3-1 and those pieces from all of the other pieces.
Uh-huh.
Your Honor, I'm about to seek to introduce and admit as the next exhibit A, B, and C.
Is there any objections to any?
No objection, Your Honor. Thank you.
182A and C.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 2096. Ms. Gilman, yes. If you could even zoom in just a little bit more on the item itself. Ms. Vallier, what are we looking at in this photograph?
So those pieces that I labeled from item 7 all of those, they all fit together mechanically into this piece.
And as far as earlier, you were testifying as far as the label maker and the different various pieces that you would label throughout the process of your physical match analysis. Do you see these in this photograph as well?
I do.
And where are they located with reference to the reconstructed piece above?
They're those little white rectangles on the piece.
So what's depicted here is the mechanical fit between items 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16, correct?
Not items 7-8 and 7-14, but the other ones, yes.
And why not those two?
They didn't fit mechanically with the other pieces.
I can't even fast
Ms.
forward.
Gilman, if I could have 2150. And again, if you could just zoom in a little. And Ms. Vallier, what are we looking at in this photograph?
I know what I'll do.
So on the right side was that piece that was just shown. And on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151. Again, if you could zoom in on that item. And Ms. Vallier, what are we looking at in this photograph?
So that's that right piece on top of the tail light from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the tail light housing, and all of the various pieces that were found in 34 Fairview, starting with the number 7?
Yes.
Shall we today? 17.
Thank you. Ms. Gilman, you can take that down. Ms. Vallier, lastly, in reference, did you also receive some debris from John O'Keefe's cloak?
Correct.
Yes.
And Mr. Officer, we can have the lights back on. Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So it was 5 different items. So it was debris collected from, labeled as coming from the clothing. There was mostly debris, some apparent fibers.
Were there any pieces of apparent plastic contained within the debris?
Yes.
Was there dirt contained within the debris?
Yes.
And that debris was labeled as an item 17-18.18. Is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those are all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes.
So you did an examination under a microscope, is that correct?
Yes.
And did you measure some of those items contained within the debris?
Yes.
Specifically, did you measure items of apparent clear plastic contained within the debris?
Yes.
And what did you measure those items to be?
The piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Thank you. I have nothing further.
Mr. Giannetti?
Thank you very much.
Good afternoon.
Good afternoon.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1. Am I correct?
Sorry, for which one?
That's the taillight, this 7-3.1. Am I correct?
3-1, I believe.
7-3-1.
The taillight is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
How long? And you were made aware of that?
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct? Or pieces?
There was an empty spot on the overall reconstruction. Yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton? In any case, you'll agree with me, there was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
I mean, it depends on what you call, like, the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And the pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
Yes.
For instance, the orange t-shirt was given or was named item number 7-17,
Yes.
and the gray long sleeve shirt was item 7-18, correct?
Yes.
And your lab is accredited, correct?
Yes.
There is a complete chain of custody from the moment the clothing was brought to the lab to when the debris was removed from the clothing, ultimately to when you're in court today handling the items, correct?
Yes. Our in-lab chain of custody extends from when we receive it to when the submitting agent, it is returned to the submitting agency.
Okay. And you have complete confidence that the chain of custody at your lab is effective at making sure that the evidence does not get lost or mixed up or contaminated, right?
I mean, chain of custody is meant to track where a piece of evidence is. The evidence unit also does inventories and audits to make sure that things are where they're supposed to be.
And you have confidence in your lab's chain of custody policies and procedures, correct?
Yes.
But you'll agree that your lab cannot control who handled the clothing before it arrived at your lab, correct?
Yes.
There are times in which crime scene technicians or criminalists from your lab actually participate in the search for evidence at a crime scene, do they not?
Some of the people at the lab are crime scene responders, yes.
There are times when they actually take custody of evidence. Again, I'm talking about people from your lab, professionals, they take custody right from the crime scene and transport that evidence to your lab, correct?
Yes.
In those circumstances, your lab would have a complete chain of custody from discovery to seizure to testing or whatever comparison you're doing until you release the items, correct?
Yes, but the electronic chain of custody doesn't start until that item is entered into our LIMS system at the lab.
Right, but when it's entered in, it would be entered in as having been seized by somebody from your lab, correct? In the hypothetical that I'm giving you.
Yeah, there's an evidence submission form that says that this crime scene responder submitted it to the laboratory.
There are other cases, however, when the evidence is brought to your lab by the police, correct?
Yes.
Local departments have access to your lab?
For evidence drop-off, yes.
The state police have access to your lab for evidence drop-off?
Yes.
And in this case, it was not a criminalist or other professional from your lab who seized the clothing and brought it to your lab, correct?
I'm not sure.
Do you have a record of that in your report in terms of who it was that brought the material to your lab?
I could look at the evidence submission form to see who.
With the court's permission?
Yes.
Michael Proctor, guessing.
Okay.
Sidebar. Sidebar swoosh. Coming up. Sidebar. Swoosh. What else have I got? Nothing that's really appropriate, but then this one gives me a laugh every time. Sidewalk. Drop a by.
You have that with you now next week?
I do.
All right, go ahead, Mr. Kennedy.
Having reviewed your reports, can you testify to the jury about who it was that brought this evidence into the lab?
So you can tell us. Okay.
So submission 7, all the items that are 7- was submitted by Trooper Michael Proctor.
Oh, Joe. Surprise.
Were you aware of the date of the incident that gave rise to this case?
Yes.
And what was that date?
January 29th, 2022.
Were you aware that the clothing that you received was seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought
What
to
date?
your lab?
What date?
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks to bring this clothing to your lab, do you?
Sustained.
Do you know where Michael Proctor stored this clothing during that 6-week period?
No.
Do you know how often he was alone with access to the clothing during that 6-week period?
Sustained.
Do you know if he had access to pieces of red or clear taillight during that 6-week period?
Dang.
Sustained. Move on, Mr. Kennedy.
Can't unring that bell.
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Yanedi. Move on, please.
One last question. You cannot vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
I cannot.
Anything further, Mr. Lally, or are you all set? Okay. I'm not curbing it.
No. Very good. Mr. Vallier, there is a separate evidence unit contained within the Massachusetts State Police Crime Laboratory, correct?
Correct.
And fair to say you have absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as chain of custody is concerned is from when you retrieve the item during your analysis and then when you return the item to the evidence unit, correct?
Correct.
And from that analysis that you performed, you found that there were 10 different items, starting with the number 7, that were a mechanical fit to 3-1, the taillight housing from the defendant's vehicle, correct?
If it's 10 items, I don't have, I can count them.
Oh. As far as all those items beginning with 7 that you went through or elucidated on your direct examination, each of those were a mechanical fit to each other and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right, Mr. Lucia, you are all set.
You are all set. She needs to come up with a different line. Or I need to make a Suno song called You Are All Set.
All right, so jurors, that is it for today.
What?
I'm told when I spoke with counsel earlier that we are still on track. I have to tell you those same cautions. Please do not discuss this case with anyone. Don't
Wonder
do
if they're gonna
any
deal with this,
independent research or investigation
possible
into this
violation.
case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off. All right, so we'll see you on Monday.
Please rise for the jury.
All right, so this has to do, I think, with the aperture report, which I have just done an analysis of. So I will copy and paste that and put it wherever I can. Copied. I might put one in Discord.
Okay.
I don't think we can create a link. Hang on.
So before we recess, I appreciate that council provided me with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated in what the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that.
You're an asshole.
Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days, We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections are noted. I'll see everybody on Monday.
All rise for the court, please.
Oh, so that's it for the day. Right. Okay. Let me just save this, and then I'll print it out and we'll go through it because I want to understand it and what's just happened. Where is it? Karen. Where do I find what I find it? There. This is aperture. Right, save it there. Now let's print this out. Talk amongst yourselves. Don't mind me. I'm just sleuthing. Did I put it important? There we go. Yeah. Oh, shit. I think I saved it as the wrong file. Fucking did, you dipshit. Save. What if I go into that PDF? Hang on. That one. Copy. Oh, I'll put it on my drive and then I can print it from
The
there.
darker part that's being measured there is the laceration. And then above the laceration, you can kind of see it, the three darker spots. All that is red on his head, and then the area around it, and it sort of formed a pattern. And it really became a big, big part of this case. Can someone who is hit by a car and falls back on their head on the ground, is it consistent with that type of a wound? And there's the laceration, and above the laceration is a wound. So I want to get your thoughts about this, because it was up on the screen for a long time, and it seems like this is going to be a really big issue in this case. Joseph Krowski Jr.
I'll take the lead on this. And here's the impactful part of the testimony of Scorty Bello. That laceration on the head, she explained in detail. That's the actual cause of death. That's the injury.
What I've been saying.
And that is consistent with a man of John O'Keefe's size falling backwards, striking his head on solid ground. The laceration is caused by blunt force impact with the ground. The skin is pushed against the bone. And she went on to explain in here, I think she talked about when people first looked at the injuries to John O'Keefe, they looked at his two black eyes and they raccoon eyes. They thought that was consistent with a fight.
No,
what that
not.
is periorbital ecchymosis.
That's right.
And when you have that brain injury, the blood, you get an intracranial bleed,
Pressure.
and the blood pulls behind the eyes, and that's why you have uniform black eyes, and that's why Alessi didn't even challenge her on that.
How about,
But I just want to make one more point. I know it's your show. But
one more point.
One more point. what's important, she's testifying to the cause of death, not the method of death. Homicide isn't even admissible statutorily in Massachusetts and most states. That's a liability question. That's a question for the jury. She doesn't know if he was pushed, hit by a car, how he got to the ground, but what she does know is the actual mechanism of death, which is the brain bleed from the blunt force trauma to the back of the head. And the defense won't challenge that.
So, but the question is, this particular pattern, the abrasion and the laceration in the back of the head, that's going to be a big issue, trying to figure out how it happened.
Well, that's true. And once again, we go back to that old issue of reasonable doubt, because if there's different theories and even the medical examiner can't figure it out, the fact that also that there were not just swelling of the eyes, but there were actually lacerations of the nose and the front, and she was specifically asked that. Would that be, if you were simply hit by a car and you hit your back of your head, why would those be there? And the question she was asked was, would that be, could that be consistent or inconsistent with a fight? And she said consistent. And again, there's different theories here, but I'm sure the prosecution will come up with another reason. But the very fact that there's room for argument here and nothing is conclusive, again, that's beyond a reasonable doubt. Really, they don't, they just don't hit it. And as I've said, I'll wrap this up by saying many times before, I've said the dirty little secret of criminal trials is they're not necessarily a search for truth, they're a search for doubt.
Yep.
From the defense side, obviously.
Yes.
Take a listen to the medical examiner. I want everyone to hear this because there was a lot of cross-examination about what wasn't found on John O'Keefe.
Assuming a fall backwards onto frozen ground and there being on a lawn with grass, would you expect to see any grass at all in the injury site?
It's possible to have grass.
Did you have any information regarding the circumstances that you said you look at in trying to determine manner of death as to whether there were any stones or rocks around the scene?
That I did not have any information.
What, if any, consideration did you make in your assessment of cause and manner of death with regard to stones or rocks?
I did not make any.
All right. Nick, what are your thoughts about the wounds on the back of the head, the lack of grass?
I mean, it's pretty self-explanatory at this point. She opined that that laceration to the back of his head would have incapacitated him. So if what the Commonwealth theory is him being struck at 12:31 in about 36 seconds, how did he use his cell phone after that? And that's why we now see Aperture wanting to change their theory of the time that John O'Keefe got struck, because two clocks don't match. So if he's laying outside in the snow after being struck by that, there is absolutely no way he's using his cell phone. So you have, the laceration in the back of the head. How did he receive those two cuts on the front of his face? Now, is he now going to say he got hit, the back and the front when he fell to the ground? I personally don't see how Scotty Bello helps the prosecution. I think this is another win for the Commonwealth in this situation.
That's why, go ahead, you go.
Well, I was just going to say that's why Hank Brennan is going to use Dr. Wolf, the neurosurgeon, coming up. Well, I know what you're going to say, Nick, that.
And you're going to be wrong, but
that the medical examiner said, well, this neurosurgeon is not qualified. However, he's a brain surgeon. He's more qualified than she is to talk about brain injuries.
So how about when defense
what
counsel
about
brings in
Renee's
their
language?
expert, and then at the end of the trial, the jury is saying, geez, I hear this theory, I hear that theory. We don't really have a smoking gun, something that absolutely nails us down. So again, if the jury just says, geez, I don't really know who to believe, then the case has not been proved beyond a reasonable doubt.
You know those black eyes are not consistent with a fight.
The two cuts
not.
are.
There's a laceration on the nose. Karen Reed, in one of her
Blind that
interviews,
with
said
glass.
she picked a piece of glass out of his nose.
And how about the eye lacerations?
That's the explained cause of the laceration on the nose. Most of the injuries are on the right side of his body, consistent with getting clipped by the car. Karen Reed said, I might have clipped her. But the point I was going to make, and why the defense is so incensed, is they were working on a flawed theory of the timeline. And what the Commonwealth raised today during the break that Matt just brought up is because they have said they've continued working, and they had said in their opening there's a variant. They now have the phone data and the text stream data completely synced where they can calibrate a 21-second difference, and her car is backing up at the same exact time he stops moving with the phone. So that in conjunction
Ian Whiffin's
with the
testimony
autopsy,
debunked Aperture's whole case.
it doesn't.
It doesn't. That's why
They
want
wouldn't
to
fight
change
so
it.
hard
That's
to
why they
keep
want
it out.
change
The fence
Hey,
wouldn't fight
you know
so
what
hard
we're
to
going to
keep it
do?
out.
Stick around, because in 9 o'clock, we're going to talk about Ian Whiffin's testimony and his timeline. But in this hour, when we come back, we're going to talk more about those autopsy photos. We are live in Dedham. Don't go anywhere.
All right. Fuck you, Vinny. Let's go through this. So I actually put the transcript into the AI, the what do you call it? The database. Where am I? There I am. Okay. Yeah. And because I don't understand the argument and what's going on and all the law and stuff, I put in all of the elements. So I pretty much asked it basically to find the hearing or argument, so to speak, that happened outside the presence of the jury last night on yesterday's testimony between the defence and the prosecution regarding the Aperture report. Now, the way that it was explained, but well, I was watching Uncivil try to explain what had actually happened, and from that argument, he said that Aperture was hired by the Commonwealth to rebut the ARCA testimony and their reports. And so they wrote a report and presented it to ARCA, and ARCA was in the process of rebutting that when they submitted an amended report that had altered the information in there in anticipation of what they believed ARCA was going to respond with. And what they'd done is they had synced the time clocks from the SUV to the cell phone, which then can mask any particular time discrepancies. And because there's been so many time discrepancies throughout the whole trial, and that the amended report wasn't disclosed either. That's why they're calling a Rule 14 or some shit. So I've asked it to explain what the issue is and the argument that was raised and what each side is claiming. So actually, can I bring it up on the... You can see it. I should be able to. Oh, look at that. So clever. What can I say? Now. There we go. How do I make it bigger? I move that. No. All right. That's the start. I don't know how to make it full screen. So you can read it better. Zoom. Oh, 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 look at me go. Fuck. There we go. That's better. Ah, much better. All right, that was my question. That is... Oh. Come on. Oh, this is my question. Sorry. This is what they go through, how they think and what they're doing, what they're searching for, what they're analysing before they give me the answer. Okay, analysis of the hearing outside of the jury. All right. The hearing outside the jury's presence involved a discovery dispute regarding expert witnesses and late disclosure of evidence. There are two main issues being debated. One, the disclosure of the Commonwealth. The Commonwealth introduced a new expert report from Aperture dated May 8th regarding timing discrepancies in the evidence. The defence argues that it is an improper late disclosure. The rebuttal expert testimony due to late defence disclosures. The Commonwealth argues that they should be allowed to have their expert, Dr. Welcher, testify in rebuttal after the defence experts are to testify because of what they characterise as late and extensive disclosures by the defence. What the defence is claiming. Attorney Alessi. Improper late disclosure. The Commonwealth provided a new expert report dated May 8th that changes previous testimony about clock drift, the time variances between different electronic devices without adequate notice. The disclosure violates discovery rules. The defence argues this report should have been provided earlier as the concepts discussed, the clock differences, have been known for months. Attorney Alessi argues that allowing the Commonwealth's expert to testify after defence experts and then again in rebuttal would improperly shift the burden of proof to the defence and provide the prosecution with an unfair double rebuttal opportunity. The defence argues that the proposed order of witnesses manipulates the standard order of proof in a criminal trial. Legal basis. There is a legitimate legal basis for the defence's concerns. Discovery rules. Criminal procedure typically requires timely disclosure of evidence and expert opinions to prevent trial by ambush and ensure each side has adequate time to prepare. Due process. The late disclosure of critical evidence may implicate the defendant's due process rights under the 14th Amendment, especially in a criminal case where the burden of proof is on the prosecution. In criminal trials, the prosecution typically presents its case first, followed by the defence, and finally the prosecution's rebuttal, allowing multiple opportunities for prosecution experts to testify could unfairly advantage the prosecution. Has the Commonwealth done nothing wrong? Procedurally, there appears to be a procedural issue with the timing of the Commonwealth's disclosure. The defence argues the information about clock drift has been known for months, making the May 8th disclosure untimely and potentially in violation of discovery rules. Morally, the Commonwealth's request to have their expert testify again after the defence experts could be seen as attempting to gain an unfair advantage in the proceedings. The Commonwealth argues that late disclosure was justified because it was in response to the defence expert, Mr. Dorbo-Dezogo. The new information is favourable to their case. They were surprised to receive this information themselves. Possible solutions for the issue. This is I asked it to give me solutions. Maintain standard order of proof. Have all Commonwealth experts testify before the defence experts, preventing the rebuttal to rebuttal situation the defence is concerned about. Additional preparation time. Allow the Commonwealth's expert, Dr. Welcher, additional time to review the defence's expert materials report. I think they've got that round the wrong way. But maintain the proper order of witnesses. Limited rebuttal testimony, which is what she said. Allow rebuttal testimony, but strictly limit it to addressing new issues raised by the experts, not rehashing previous testimony. So that's her ruling, that one. And the defence were asking for it to be excluded. So the most extreme remedy would be to exclude the Commonwealth's May 8th expert report due to its late disclosure. Context and significance. This hearing demonstrates a critical issue in the Karen Reid murder trial regarding timing evidence. The dispute centres on expert analysis of electronic timing data from text messages, phone activity, the vehicle black box. The timing of these events appears to be central to the case, as Attorney Brennan mentioned the most important issue in this case regarding the expert testimony. The trial involves determining precisely when certain events occurred, and these competing expert analyses could significantly impact the jury's understanding of the timeline of events. The judge indicated they would take this information under advisement and consider the appropriate way to handle the expert testimony and discovery issues. So once I've downloaded today's transcript and uploaded it again, I can then get them to analyze her her response and her findings. So that's what that was all about, apparently. Now I understand. See, I learn something new every day. You guys are talking about fishing, are you? Oh, Lord. Hell. Let me go back. I've missed a whole. I can't stand Vinny now. Maybe I should write a book or make a show or more. Oh, Teresa, did you get the link for, and Elizabeth, the documentary? And let me know if you can open it, because I only sent you the first episode. If you can open that, I'll send the rest. Maybe I should write a book or make a show. Yep. We already have the Jen McCabe movie coming out. Oh, really? Are you for real? Oh, my Lord. Oh. Give me strength. In the movie, both Jen and Karen unalive John. So, oh, you are so full of shit. If you need to go to Teresa's pond, you'll catch fish there. I'm having to go Saturday if storms don't knock me out. Hope you get lots of fish. Oh, there you go. Check out my goldfish pond. Yeah, on Pet Pics. I'm the opposite. I like fishing, but I don't like baiting them. Yeah. In Australia, I think my favourite fishing is surf fishing. That is fun. Really fun. I don't know if you guys have done that over there, but it's, basically using surf rods. So they're massive, big rods, and you fish off the beach with an esky beside you and a nice comfy camp chair in the sun. So, yeah, it's great. Ew. Gross. Yeah, we have a lot of trout over here in freshwater. Yeah. I used to ride when I was younger. Well, you got to get back on the horse, don't you?